Good afternoon and welcome to this meeting of the Local Review Body of the 11th of June 2025. I can confirm that the meeting has been properly called and is quorate. Can I first ask members to appoint a chair for this meeting, please? Councillor Giusti.
I would move that we appoint Councillor Dempster as chair.
Any seconder? Councillor Slater. Councillor Dempster, are you happy to accept that nomination?
Yes, if there are no others, Tracy, yes, I am.
Thanks, Chair.
In that case, shall I proceed?
Yes, please do, Chair, thanks.
Good afternoon, members, and welcome to this meeting of the Local Review Body. This meeting has been live streamed and recorded, and the recording will be made available on the Council website for public listening. Remote participants, please follow the good practice guidance, which includes muting microphones and switching off your video when you're not addressing the meeting, writing speak in the Teams chat function when you want to contribute. No material should be posted in the chat function if it's intended as part of the discussion. User standing orders apply, including any votes should be undertaken by a roll call. All members should speak clearly and directly into the microphone when making contributions, and when referring to reports, please provide reference to the relevant page and paragraph to allow everyone to follow. Can I come to the Sedrent? Apologies and my approval of members' remote participation, and I approve members' remote participation. Tracy, can you provide Sedrent and apologies, please?
Thank you, Chair. We've got 5 members present, 2 members present here in person at Council HQ, being Councillor Giusti and Councillor Slater. 3 members present on Microsoft Teams, being the Chair, Councillor Blake and Councillor Lowe. Not present as Councillors Hill and Councillor Hislop. Thanks, Chair.
Thank you very much, Tracy. A declaration of interest, members, does anyone have a declaration of interest? I don't see any hands up and I don't see anything in the chat function. So I will presume that there are no declarations. Tracy, can you now take the Local Review Body through the documents and papers for the meeting, please?
Yes, thank you, Chair. Just for members that are online, Councillor Hislop has just joined the meeting in person here at Council HQ. So we have got 3 notice of reviews for consideration at the meeting today. First item, number 4, Solway Point, 1 North Carsthorne, refusal of planning permission for erection of dwelling house, amended floor levels to that previously approved under reference 211453 FUL, retrospective reference 232743 FUL. So within your papers, members, you've got the notice of review dated the 28th of February 2025, submitted by McKay Planning Agent on behalf of Mr and Mrs Smith, the applicants, and received on the 3rd of March 2025, and that's pages 17 to 108. You then have your report on handling and relevant correspondence, which is on pages 111 to 189. You have the observations of the appointed officer on the applicant's agent's notice of review and further comments from representatives on pages 193 to 201. Comments of the applicant's agent on observations of the appointed officer and further comments from representatives are on pages 205 to 220. You've got the planning application form submitted on the 18th of December 2023, associated plans, reporting information registered as valid on the 3rd of January 2024, and that is pages 223 to 234. The decision letter from Dumfries and Galloway Council dated the 12th of December 2024 is on pages 237 to 240. Relevant extracts from Dumfries and Galloway Local Development Plan 2 and National Planning Framework 4 are on pages 243 to 269, and the photos of the application site and locality on page 273. So the grounds for the refusal, as detailed on page 238 in your pack, are: the proposal is contrary to the Scottish Government's National Planning Framework 4, Policy 22, and Dumfries and Galloway Local Development Plan 2, Policy IN7, in that it would be located entirely within an area at risk of coastal flooding. It has been demonstrated that the dwelling house would be at an unacceptable risk of flooding, and with a reduced finished floor level and updated floor level data, the development would be more vulnerable to flooding than that previously approved. On page 18 of your papers, the notice of review, the applicant's agent has asked that the review be dealt with by means of one or more hearing sessions. It has been stated by the applicant's agent that this is necessary in their view because the matters of consideration in relation to this review case are complex, and on that basis there should be the opportunity to speak and ask questions which only a hearing session would enable. So the grounds stated in the notice of review and in the comments of the applicant's agent on observations of the appointed officer and further comments from representatives from pages 21 to 41 and 205 to 217 in summary are: the planning history establishes the principle of a dwelling house on this site over many consents and years. The avoidance principle, that is, not building in the flood zone, as set out in MPF 4 Policy 22 and LDP 2 Policy IMV 7, is therefore not relevant as extant consent exists to building a dwelling house here without complying with current SEPA policy and flood level data. Granting this development for a smaller dwelling house with mitigation would reduce the potential for displacing of flooding which impact neighbouring properties when compared to the extant consent. Given the planning history, SEPA's objections and the objections from the Council's flood risk management team must be given little weight. It is not possible to follow the avoidance principle by not building a dwelling house here, nor is it possible to design an acceptable building on the site which would reasonably satisfy SEPA's recommended finished floor level of 8.9 metres AOD above ordnance datum. Compliance with the approved finished floor levels of 7.8 metres AOD, which is contained in approved plans and not conditioned, would cause the development to be in breach of the condition number 3 on access gradient. All the properties at North Carse are below SEPA's recommended finished floor level, and all the properties in Carse Thorn are identified in SEPA's flood map as being at medium to high risk of coastal flooding. The proposed floor door for the dwelling house would provide protection to 7.9 metres AOD, which is 100 millimetres above the previously approved finished floor levels of 7.8 metres AOD, thereby making the dwelling house less at risk of flooding than the dwelling house as approved. Due to the coastal source of any potential flooding, satisfactory refuge would be available as an access road to the south would allow safe egress to the main road during a flood event. The risk to life and safety is therefore negligible. Further, refusal of the application would leave the only option available to resolve the difference in floor levels to be the complete demolition and rebuilding of the dwelling house. Given the policy requirements to conserve embodied energy and carbon and reduce emissions in line with MPF 4, demolition is the least preferred option and would be unreasonable given that an alternative option exists to amend the approved finished floor level and control mitigation by granting this review. The reasons for refusal based upon MPF 4 Policy 22 and LDP 2 Policy IMV 7 are flawed and on the planning balance the principle of reasonableness. There are sufficient material considerations which weigh in favour of granting this consent by this review. Therefore, respectfully request that permission be granted with a condition in place to control the proposed mitigation measures as: the dwelling house hereby granted planning permission shall not be occupied unless and until the proposed retrospective property flood resilience measures as stated in the submitted flood risk assessment have been installed. Given the particular circumstances, extensive planning history and the extant consent on this site, the technical error involved in this case can be resolved by granting consent without setting any precedent. Granting this case as an alternative to pursuing enforcement action would fulfil the Council's role and responsibilities of the Flood Risk Management Scotland Act 2009. The appointed officer accepts that the extant planning consent is an important material consideration which justifies a departure from the development plan. The appointed officer accepts that mitigation may reduce the level of flood risk relative to the finished floor level as built by reducing the likelihood of and speed of water entering the property and assisting in recovery after a flood event. The Scottish Flood Forum appraisal of the property recommends a variety of suitable flood protection measures which could be put in place retrospectively. The flooding engineers who prepared the submitted flood risk assessment also recommended a variety of suitable flood protection measures. It is clear that mitigation in the form of suitable flood protection measures would satisfactorily reduce the flood risk to the constructed dwelling house. Requiring the implementation of flood protection measures would avoid the need for enforcement action to seek the full demolition and reconstruction of the dwelling house. It would be proportionate and reasonable for the planning authority to require and control this by granting consent subject to a suitably worded condition. You then have a list of your development plan policies on pages 243 to 257. So the main issues for the local review body to consider are: noting the hearing session request from the applicant's agent, are members persuaded that there is sufficient compelling set of reasons to hold a hearing session or sessions in this case? In this regard, it is recognised that this process would need to be the subject of a formal procedural notice to all relevant parties, setting out the hearing arrangements at a future date. Notwithstanding the foregoing consideration, would members be persuaded to engage in further process, for example, to obtain additional written information, such as from SEPA and the flood risk management team on the proposed mitigations, and/or to undertake a site visit in this case? In this regard, it is recognised that this process would need to be the subject of a formal procedural notice to all parties, setting out the relevant arrangements at a future date. Does the proposal comply with the terms of the development plan? In particular, does the proposal fail to meet the terms of MPF 4 Policy 22 and LDP 2 Policy IN 7, in that the dwelling house is located entirely within an area at risk of coastal flooding, where the dwelling house is at an unacceptable risk of flooding? Additionally, on the basis of the reduced finished floor level and updated floor level data, is it accepted that the development would be more vulnerable to flooding than that previously approved? If it is considered that the proposal does not accord with the terms of the development plan, are there a set of material considerations of sufficient weight to justify a departure from the terms of the development plan? If so, on what grounds should such a decision be made? And what reasons would members give for such a decision if it was considered that the proposal departs from the terms of the development plan? How much weight would members wish to give the history of planning applications at this site as a material consideration? How much weight would members wish to give to the suggested mitigation measures put forward by the applicant's agent? How much weight would members wish to give to the situation in relation to the finished floor levels of the existing neighbouring houses at North Carse? If members are minded to reverse the appointed officer's decision and instead grant planning permission for this proposal, what set of conditions and reasons would members wish to see attached, if any? The developer has suggested an additional condition, and are members content with how this is worded? Noting that if members are minded to reverse the appointed officer's decision in light of SEPA's objection, Scottish ministers would require to be notified of the proposed decision to grant permission. If members are instead minded to vary the terms of the appointed officer's decision, what changes to the specific reasoning for the decision would be required, and which additional policies, if any, would be referenced? So, having outlined the documents within your papers, it now falls to the local review body to determine whether it has sufficient information to consider the review. It is confirmed that no representations from any party will be heard today. The options available to the local review body today are: it can decide it has sufficient information before it to enable it to determine the review today, request further information in the form of written representations. The local review body will be required to state precisely the information it is seeking and who must provide it, resolve to hold a hearing, again specifying who will be invited to speak and on what matters, or resolve to hold a site visit accompanied or unaccompanied. This can be done in conjunction with any of the above, but would not allow a decision to be made today. If the local review body resolves that it has sufficient information and that no further procedure is required, then the local review body has full powers to uphold, reverse or vary a determination. The decision notice will include a statement of the terms in which the planning authority has decided the case reviewed. A planning advisor is present at your meeting today. It's confirmed he has not had any involvement in this case prior to the submission of the notice of review. He was not the case officer or the appointed officer for the application. He is here to provide independent advice as needed on matters of planning policy, law or process to the local review body. And a solicitor is also present here today, and she will act independently if the local review body require any specific advice on matters of law. So if members are now clear and no further clarifications required, I will ask the Chair now to lead the debate, and in the first instance to lead the local review body through your agenda papers today. Thanks, Chair.
Thanks very much, Tracy. Thanks for that comprehensive setting out of the situation before members. I We'll go through the index of contents with members if members are happy on an item by item procedure, and if members have any questions or observations, they can either stop me or make an indication on the chat function, and I will invite them in. So the first item is the notice of review dated the 28th of February 2025, submitted by Mackay Planning Agent on behalf of Mr. and Mrs. Smith. The applicant received the 3rd of March. It's pages 17 to 108. Does anyone have any questions on? And I also will ask our planning officer to take us through any photographs that he might have at the end of the procedure on the papers that we have on the agenda item number 4. So pages 17 to 108. Are there any questions on that particular element of the papers? Don't see any. So item 2, report on handling,
Sorry,
determined
Chair,
under.
Councillor Hislop in the room wishes to speak.
Thank you. I didn't see a hand up, Councillor Hislop, but by all means, Councillor Hislop, please.
Just wondering, could you refer me to which plan relates to the original planning permission where it was 7.8 metres? Is that the one on page 69?
I take it you're asking the planning officer is here to support us today, Councillor Hislop.
Yeah.
Thanks, Chair. Happy to answer that. If you look at page 87 of your papers, you have the location and the site plan for the application reference 211453 FUL, which was the previous application. And you've also got a dwelling house plan for the same application on page 89 of your papers. And if you look at the location and the site plan, that has the finished floor level annotated on it.
Thanks for that, Robert.
Follow up on that. And
Certainly.
normally, is that the only place that you would see the finished floor level, or would you see it actually in the house elevations?
Robert?
Normally, I would expect to see it on a block plan or a site plan in relation to a fixed and identifiable datum point, such as, say, for example, a level on a pavement or a manhole cover, that kind of type of thing. So it is relative, and it should be. I mean, I was always taught that you had to have a fixed and identifiable datum point on the plan, and that was a better method than actually relating it to datum, above ordnance datum, which is the other way of doing it. So one of those two methods is fine, but yeah, it's normally on the site plan or block plan.
Thank you.
Thanks, Councillor Hislop. Are there any other questions on the notice of review? In that case, number 2, report on handling determined under delegated powers and related correspondence, pages 111 to 189. Does anyone have any questions on item 2? Again, I'm happy to be called back if I miss someone. Move on to item 3, observations of the appointed officer and the applicant's agent's notice of review and further comments from representatives, pages 193 to 201. Any questions or points of clarity in that? On to item 4, comments of applicant's agent on observations of the appointed officer and further comments from representatives, pages 205 to 220. Item 5, planning application form submitted on 18th of December 2023, associated plans and supporting information, registered as valid on 3rd of January 2024, pages 223 to 234. Any questions or observations on that? 6, the decision letter from East Galloway Council dated 12th of December 2024, pages 237 to 240. 7, the relevant extracts from East Galloway Local Development Plan 2 and National Planning Framework 4, pages 243 to 269. And lastly, 8 photos of application site and the locality, page 273. So I'll ask Robert if he has any photographs that he might put up, as well as the ones we already have contained within our papers. Do you have any photographs you can share with members, Robert?
Thanks, Chair. Yes, but before I do that, I mean, I'll give you the usual caveat that these photographs were provided to me by the appointed officer. I haven't undertaken a site visit myself. Before the meeting commenced today, though, the applicant's agent did explain to me he was concerned about the kind of quality of the pictures that were shown, just so that you're aware of that. So in the interest of balance, as well as showing you these pictures, I feel that I should also have the pictures that have been supplied by the applicant's agent in support of this application. So for the avoidance of doubt, those will be the pictures of the dwelling house in pages 21, which is the front cover of the review statement, pages 135, which is the front cover of the flood risk assessment. Those are the same picture, and also the same pictures used in page 205, which is the response from the agent to the comments of the applicant's officer. The other pictures are within the flood risk assessment on pages 145 to 146. So once I've showed you, or shown you rather, the pictures I've been given by the appointed officer, will hopefully be able to move on to those, and they'll appear up on the screen in front of you as well, so that you have a balanced consideration, because again there were concerns about the pictures that have been supplied to me by the appointed officer. That there's
And
also
before
an
you
issue.
do, Robert, do we already have these pictures in the papers,
Yes, all of these pictures are in the papers in front of you
including
today.
the ones from the agent?
Yes.
Yeah, good.
Okay, so just firstly in the PowerPoint presentation, there are only 2 pictures, so moving on. The first one is a view of the site from the C13N public road. You can see the dwelling house on the right-hand side there. It's a distant picture. You can't see the finished floor level. I think that's really the primary concern. The second picture is similar. It's a more close-up view of the site and the dwelling house, but again, it's taken from that public road at distance from the site. Now, moving on to the picture that's on page 21 of your papers. So this is the one that's on the front cover of the notice of review statement. That's it on the right-hand side there. Now, you can see that's a much closer view of the dwelling house. You can see it's got that relationship with the adjacent dwelling house to the left. You can see how the finished floor level relates to the road and the pavement surrounding it, and also the garden area and the driveway as well. So that's hopefully helpful. Again, that's the same picture you've got on page 135 and page 205 of your papers. So the other pictures that form part of your submission are on pages 145 and 146, which is just scrolling down these pictures here. So you've got the top left picture, which is basically the same as the one you've seen. Then you've got a much more detailed picture top right of the side of the house, air brick shown at ground level, and it says that the weep holes there that you see annotated are 25 centimetres above ground level. You've then got the bottom left picture, which shows the house. I'm not sure if there's an annotation in that beneath it. Possibly not, but then in the right hand side, the photo 3 just says rear garden of property. Bottom right, photo 4, rear doors of property with minor slope up, approximately 10 millimetres. And then over the page onto 146, you've got another 4 pictures. So top left, rear of the property's northwest corner. Photo 6, front of the property. And then you've got the other photos 7 and 8, which show the beachfront of Carsthorne at low tide. And the tide charts show a variation in the tide levels of up to 8 metres. So there's quite a large tidal range there. So those are all the pictures I have in the review papers that are in front of you today. Like I said, there has been a query over a point of procedure, but I need to leave that to the clerk and the legal advisor to address. Thanks, Chair.
Thanks very much, Robert. Okay, members, then we move on to the grounds of refusal. And we've already had that explained to us by the clerk. The requested method of determination is completely in our hands. So, does any member have any particular view on how we proceed, whether we have enough information before us, whether we might want to organise a site visit or accede to the request of the applicant's agent and hold a hearing. I see Councillor Justy has his hand up, followed by Councillor Slater. So Councillor Justy first, please.
Thank you, Chair. It's interesting seeing that we've got two houses or multiple houses on this site, and reading the officer's report, I'm at the very bottom of that, which is the... sorry, I just went to the top again, sorry. Going to the conclusion of the officer's report, I was seeing that we're talking about a difference of 50 centimetres here in height level. I think it would be interesting for the members to go and see this and have a site visit, just to see how it fits in and maybe get a bit more information on the flooding profile of the area. Because it looks like this is the house behind, it's not the front house to the sea. And the pictures, if I'm being honest, didn't do an awful lot of justice in the sense of the height of the other house that's next to it compared to this one. That's what I'd be interested to go and see, Chair.
Okay, Councillor Justy, we'll have that as a debate. Councillor Slater, please.
Yes, I would agree with Councillor Justy for a site visit. I would agree to have a site visit.
Fine. I think then it'll depend upon other members. Does any other member have an alternative point of view? Councillor Hislop, please.
Chair, I'm not sure about a site visit, but then I know that area quite well, as I've been down there once or twice to use this, is it Steamboat is down there. But there's sort of things that are saying that it's a technical issue. What was that technical issue? It doesn't explain that really well, other than, from my layman's terms, the builder got it wrong and didn't read the plans right, which would say it's sort of his fault rather than anything that's anywhere else. But I don't know whether that would justify bringing them in and holding up today's proceeding to actually bring them and say what actually happened and find out more about that, because to be honest, if there is a reason why it didn't happen, technically, there might be mitigation there, but if there's just a case of somebody's read the plans wrong and hasn't worked in the datum, then they haven't got written permission to change their application as far as I'm aware. So they should do the plans or build it in accordance with the plans they've submitted. So I might be tempted, but I'd like advice on that, if that's an issue we'd need to consider, to have a hearing.
Okay, we can have a discussion. I'd be concerned if we were looking to put in a builder to inquire about whether they made a mistake or no. I think we were dealing with an application and the fallout or outfall for that application. I think as well, Robert made reference to some other information or request that he would leave to the clerk and our legal representative to advise us. So maybe it's a good time. It might help shape the thoughts of members. If there's something, if it's not new information, then I think maybe we should give it some thought. And if it is new information, members are willing to accept it, I'd be happy with that as well. So I don't know whether maybe Tracy or Clark and Laura can enlighten us, shall we say, on the element that Robert is not authorised to share with us. Tracy first, please, and then Laura.
I'll defer to Laura, Chair, thanks.
Laura, our legal advisor, please.
Chair, I haven't had the opportunity to discuss this directly with the agent, but my understanding is he raised concerns about the use of the photographs as they had not been on the public portal, and the applicant and the agent had not had an opportunity to comment on them in the note of review. And it was in light of that concern that Robert, I believe, has redressed that by providing or highlighting the photographs that were already provided to yourselves, so that you weren't solely looking at the photographs that the case officer had taken for their own reference, but you were also looking at the photographs that the agent had supplied.
Thanks, Laura. That's really helpful. So there's nothing that we're not aware of within our consideration today. We've now seen the photographs. So at the moment, Councillor has undecided whether to ask it. I presume we could hold a site visit, and based on the outcome of that, we could then decide to have a hearing as well. at a different time, because there is no limit on what we can and cannot do. So I think, and I'll ask Laura and Tracy again, I presume that this will follow the same procedure that the Planning Applications Committee does. In other words, if there's a proposal for a site visit, debate stops and we then convene a site visit. Is that right, Tracy? And is that right, Laura, please?
Thanks, Chair. Yeah, members can also ask for additional information as well as a site visit. It's really in members' hands, so if there's other information you want to discuss or perhaps have on the site laid out for inspection when you get there, that's an opportunity now to discuss that before we come to a conclusion. But members are not solely limited to just holding a site visit. They can also request for additional information on top of that as well, Chair.
Yeah, I think Councillor Juicy said that. Tracy, he said he would like some information on flood or flood flow, and we'll get that. It was just simply a case of the debate doesn't go on was the question. We simply decide what we need from the site visit or what information we need in conjunction with the site visit. Councillor Hislop, did you want to come back in again?
Chair, if that's the case, I would be happy if we got a reason. What is the technical or the technicality why the house wasn't built at the proper height so that it comes back? And I suppose the other one is, who has say over measuring that height? Because there's reference that building control had been out and didn't take an action, but is that relevant or irrelevant at this point?
Okay, thanks for that. Maybe we should set out then exactly what we want. So, and Councillor Juicy is the proposer and Councillor Slater is the seconder. So, Councillor Juicy first, you asked for a site visit to go and view the location, and what additional information did you want?
I would like to see the site and how the levels with the other house that seems to be closer to the water. Also, I would like to see more information on the flood risk that's actually there, and it might be somewhere in the papers. Maybe I've missed it, but I would like to see that. And I just think it would be quite interesting to see this one and compare it to their house. I think the pictures that we've had in front of us today, they've not shown a great representation of it. And I think it would be worth the committee actually going and taking a look to see if there is a proper risk here.
And are you happy if we ask some flood risk management team to provide any additional information they can that might help us?
Absolutely.
You be content with that? Yeah. And Councillor Hislop, you would like to see the explanation as to why the disparity in flow levels came about, whether the council have a duty to follow that through the building control, building standards team, or whether that's solely the responsibility of the applicant, agent, and whoever it is that constructs the building. Is that correct?
Yes.
Can we achieve all of these things, Robert? Is it reasonable to look for that? And then I'll ask Laura and then Tracy the same thing. So Robert first, please.
Thanks, Chair. I can certainly give my views on what you've discussed. What I would say is the applicant has gone to the trouble of preparing a detailed flood risk assessment, and that appears in your papers, pages 135 to 181. So that's already in there. That was submitted on the 29th of May 2024. I can see that there was consultation with SEPA on the 18th of June 2024. So I think there is, clarity on what the flooding issue is here in relation to what's expected now. In relation to the planning decision, you can look at the actual decision notice for the previous application, which is in your papers at pages 99 to 108, and I don't know if it says it explicitly. It possibly does. So if you look at page 101, it mentions the council granting planning permission. It gives the description in accordance with the details and plans accompanying the application. So that's clear. And it says the approval is also subject to compliance with the conditions below, which may override details what are shown in the approved plans. Now, it's a planning application you're looking at today through a notice of review process. So you have to really look at material considerations insofar as they relate to that planning application. But the onus is on the applicant to basically implement the permission they have. And what they've done in this case is they've implemented a slightly different dwelling house to that which had previously gained permission, and that is the crux of the issue here, if you like, Chair. So I think I'm just struggling to understand what additional information you would be looking for in terms of the flood risk and identifying what that is, because I think that is fairly clear. You've also got, I should have said this, you've also got a response from the Council's Flood Risk Management Team Leader, which is from the 15th of January 2024. Admittedly, there isn't a response following the submission of the flood risk assessment, so by all means I think that would be a valid thing to seek at this point in time.
Okay.
There is the question which was raised by the Council's solicitor prior to the meeting as to whether or not you would want to actually get a comment from them, from SEPA and the Council's Flood Risk Management Team, specifically on the mitigation measures that are being put forward. That might be quite helpful too. So those are just my thoughts, certainly in relation to what's been discussed, Chair. I don't know if that helps or not.
Yes, it helps it very much so, because I'm sure every member would want to discuss how the mitigation measures might fit in. But I was keen to understand whether or not we could debate that today, because at planning in general terms, you don't debate beyond the proposal to conduct a site visit, and you then debate again when you're back in session afterwards. But if it's competent, I'm happy that we discuss any mitigation measures either today or when we return from the site visit, because I'm sure that'll be something that members will have in mind. And I think members would want a response from both our own FRMT Flood Risk Management Team and SEPA on the submission by the applicant's agent in terms of the flood risk, and I'm sure members would want that. Councillor Giusti.
Thank you, Chair. I'm just quickly reading the applicant's submission of their flood risk management. I hadn't actually seen that in my original reading of my papers, unfortunately. There's a lot of information in here. I think it actually satisfies the questions I had, but it would be for the committee to decide on that if they are confident.
Okay, and does that mean you'd still want a site visit to see the locality? You're just satisfied that there's enough detail in there for you, and especially since we're asking for a response from both our FRMT and SEPA?
If the committee feel that they would like a response from the flood risk management team in SEPA, I think it'd be worth doing that due diligence and having that site visit just to see how this lies and how this application does fit in with its area, and if it is at risk of being in a floodplain. But looking at the work done by the work that's been submitted by the applicant, I think that it looks reasonably safe to me that we don't have a flood issue, but I'll put that back to the members if they're willing to go for a site visit and to just clear that up.
It was your proposal, Councillor Giusti, but I'll go to Councillor Islip first, see if he's any other issues he wants to raise, and I'll come back to you and Councillor Slade to see whether or no you want to proceed with a site visit, and then if no, we can carry on with the rest of the business today. So, Councillor Islip, given that your question was slightly different from Councillor Giusti, your view, please.
Chair, it's just down to the fact that somebody said there's been a technical reason why, or a technicality. Now, if it's just a mistake, then sometimes you have to hold your hands up to mistakes and say we did it wrong, and then we change it. Could be an expensive mistake, this one. But I have slight concerns about accepting what the applicant said about flood risk management, because you've other houses in that locality, and if you're doing anything that might abate the chance of your house flooding, you might increase the chance of other properties flooding. So I'd have concerns about not getting responses back from SEPA or our team at the FRMT to just say what they felt on exactly what the new information is with regard to the flood risk plan.
Okay, before we make a final conclusion, I've got to make one more visit to our legal advisor, Laura Whitelaw. Laura, please, can you reassure members that we can legitimately request a response from SEPA and FRMT and then make a decision based on the feedback from them.
Pardon me, Chair. It is absolutely within your gift if you feel that you require that further information to be able to determine this matter, to seek input from SEPA and the FRMT on the flood risk assessment that you've received from the agent, with particular reference to the mitigation measures that they're suggesting would mitigate any of the danger which has been highlighted. As the planning officer had mentioned, that was something which I had suggested when we were considering the clerk's notes, that members may want to get that input from them. And I would also agree with Councillor Hislop that when there has been a request for a hearing, it would be useful to know what that hearing is to be on, rather than just saying that there's technical matters that need to be addressed. It would be useful to know what particular points the applicant is looking for to be addressed at that hearing.
Okay, so you're suggesting we contact, because I don't think Councillor Hislop ever formally proposed a hearing. I think he seemed to me to be willing to wait until a site visit had been conducted before considering whether or not a hearing was then an appropriate approach or not. But I'll leave that in Councillor Hislop's capable hands. What are you thinking, Councillor Hislop?
Chair, if a written submission can be given as to where the technicality came from, that might suffice rather than having to hold a hearing. We could take the written word to see what the technicality was. But it's just, we've got someone saying there was a technicality and not explaining fully what that technicality was. You know, was it just a mistake by the digger driver? You know, I don't know. That might be their view of a technicality, but I would like to know what their explanation of a technicality was. So that's maybe something that we need to ask for from the applicant.
Okay, well, it seems as if at this moment in time, there isn't an urgency for a site visit, but we do want to understand what the mitigation measures might impact either on the dwelling or adjoining dwellings, and a written submission from the applicant's agent on what the issues are that they wanted to. I think they suggested it was quite complex, so maybe a written response would be far more appropriate than a hearing initially. We can still hold a hearing if we feel that that's an appropriate route to go. So it would appear at this moment in time, we simply want further information from the FRMT and SEPA in relation to the mitigation measures that have been proposed in the submission by the applicant's agent, and we want a written response on all matters, especially technical matters that the applicant's agent referred to in the submission. Have I encapsulated that correctly? Is that how members feel we should proceed at this time? Councillor Justin, Councillor Hislop, then we'll move on.
Sorry,
I will seek legal advice though.
did you call me in there, Chair?
Yes, just to see if you're happy now at this moment in time without a site visit, but with additional information being sought from SEPA and FRMT relating to the submission made by the applicant's agent.
I'm happy with that, Chair. I'm happy with that, Chair. Sorry, I didn't quite get my name when you called it there.
My apologies. And then Councillor Hislop, are you happy with that written submission relating to all aspects that the applicant's agent might want to draw our attention to, especially the reason for the floor levels being different?
Yes.
Thank you. Are we in a position to conclude and carry on with these two requests? I'll ask our clerk, Tracy, and then I'll just get legal advice from Laura. Tracy, please.
Thanks, Chair. Yes, I'm happy that members have agreed that they would request further information to allow them to enable to determine this review, and that is summarised by yourself. So you're requesting written submissions from the applicant on the technicalities and covering all matters and why the house was not built at the appropriate height as approved, and requesting response from SEPA and the flood risk management team on mitigation measures and any impacts on neighbouring dwellings. Of course, when members do reconvene and receive this information, you can always decide that you still wish to undertake a site visit at that point if members do so wish to do that.
That's really helpful, Tracy, and I presume that you'll just simply call a meeting once you have received the information that members are looking for.
Yes, Chair. It will be dependent on the diary, and Robert will obviously give time to contact the applicant and give them time to respond, so members will be notified of any reconvened meeting.
That's great, thank you. Have we anything else to do, Laura, or are we happy to proceed with that as we've set out?
Happy to proceed with that, Chair. Thank you.
Okay, members, thank you very much. That's a decision, and we will all be notified in due course of a new meeting date and time. I take it the usual procedure, we keep the papers we have, but the additional information was circulated in advance of the meeting. Will that be right, Tracy?
Yes, Chair, that's correct. A supplement pack will be issued to you, so it will be available online as well as per your normal papers. But if you could keep hold of your papers, it will just be a continued meeting. Thanks.
Yeah, that's great. Thank you very much for that, Tracy. Okay, members, we move on to agenda item 5. Do you want to take us through this agenda item again prior to us debating it, Tracy, please?
Yes, thank you, Chair. So item 5, Hazelberry Farm, Tundergath, Lockerbie, refusal of planning permission in principle for erection of dwelling house, reference 231495 PIP. So you've got your notice of review dated the 7th of March 2025, submitted by John A. McCall, agent on behalf of firm of S&L Dodd, applicant, pages 281 to 295. Got your report on handling, determined under delegated powers and related correspondence, pages 299 to 341. Observations of the appointed officer on the applicant's agent's notice of review, pages 345 to 347. Comments of the applicant's agent on observations of the appointed officer are on pages 351 to 353. Planning application form submitted on the 14th of July 2023. Associated plans and supporting information as registered as valid on the 26th of July 2023 on pages 357 to 381. The decision letter from Dumfries and Galloway Council dated the 12th of February 2025 is on pages 385 to 388. Relevant extracts from the Dumfries and Galloway Local Development Plan 2 and National Planning Framework 4 on pages 391 to 419. And photos of the application site and the locality are on pages 423 to 424. So the grounds for refusal, which are on page 386, are the proposal is contrary to National Planning Framework 4 Policy 17 and Dumfries and Galloway Council Local Development Plan 2 Policy H3 and the related supplementary guidance, which permit the erection of new houses in the countryside only in special circumstances identified in the development plan, and none of these circumstances apply in this case. Specifically, it has not been satisfactorily demonstrated that there is either an essential need for a second dwelling house on the land holding at Tundergath Mains, or a genuine robust justification for a dwelling house in the proposed location in operational terms. On page 281, the applicant has asked that the review be dealt with by means of a review of the relevant information that has been provided without any further procedures. So the grounds stated in the notice of review on pages 281 to 295 and in the comments of the applicant's agent on observations of the appointed officer 351 to 353, and in summary, new matters are being raised. During preparation of the local review body submission, research was carried out on previous applications of a similar type, and the results are shown within the submission document HF2, which appears on pages 291 to 292. These are new matters which could not have been included in the previous submission, as they were only identified during preparation of the local review body submission. We would be grateful if you could consider the reasons as exceptional circumstances, as the new matters raised may have encouraged the appointed officer to approve the application had this information been available to and provided during consideration of the application. The email from the case officer dated 5th of February 2024 states that the draft report sets out the case for approval. In her email of the 23rd of September 2024, the case officer confirms that the application was to be recommended for refusal. Following an email to the case officer dated the 23rd of September 2024, a further email sent on the 21st of December 23 to the agent from the case officer provides that she can see the argument for the need for a full-time worker to be housed at Hazelberry and can set out the points that are generally met in relation to the operation of Tundergarth Farm. In the same email, the case officer states we cannot see the justification for the siting. All the supporting documents demonstrate the absolute need to have a house located where shown. The applicant would be happy to locate the house in the position of the existing buildings which are intended to be reinstated for agricultural use. The need for an on-site experienced specialist worker has been demonstrated in all the supporting documents lodged with the original application. The site of the proposed house is located in what was the hub of the farm known as Hazelberry Farm, and this can be identified on the land ownership plan lodged with the application. Security and welfare of the stock is paramount, and the location of the house will provide the agricultural worker with excellent visibility to the fields, which will enable them to attend quickly where an urgent need is required to treat animals who have fallen ill or been injured. The planning permission in principle application should have been approved, as it was very similar to application reference 220366 FUL, which was approved on the 31st of May 2023. There was no essential need for a house or for an agricultural worker within that application, but the essential need for a house with an agricultural worker at Hazelberry has been clearly demonstrated, and this has been accepted by the case officer in her email of the 21st of December 2024. Historic photographic evidence has been provided to show that a house did exist on the farm, and this provides additional reasons to approve the application. A replacement house is proposed in this case with the curtilage of the original house and steadings. The application meets the criteria relating to replacement dwellings, as it was complete to more than wall height in around 1950 and has since been reduced to a derelict state, but its previous use as a house is still very evident. The application was lodged for a dwelling house and garage essential for an agricultural worker, and on that basis the need has been accepted. It was unreasonable to refuse the application, especially as the proposed dwelling house would be located within the curtilage of the original farmhouse and steadings. The material considerations which justify a departure from the development plan are provided in detail in all the supporting documents. The submitted labour requirement report confirms that 13.92 labour units are required for farming operations at Cablefoot and Hazelberry, with 4.5 of these hours required at Hazelberry for animal welfare and security during normal and out with normal working hours. The appointed officer has confirmed that there is a need for an additional full-time worker to be housed at Tundergarth at Hazelberry Farm. The appointed officer states that she cannot see the justification for the siting of the dwelling house, but it can easily be relocated within the curtilage of the original farmhouse and steadings if required. The farming industry is experiencing very difficult times, and farmers must be encouraged and supported to enable them to retain and expand their businesses to maintain their viability, and planning departments within local councils can make a major contribution to their success by making favourable decisions on agriculture-related applications. Since the application was lodged in July 2023, the stock has increased due to calving and lambing, and this has involved considerable additional work for the low number of workers on the farm, and it is critical that an employee with additional full-time agricultural worker is resident on the farm in the interest of animal security and welfare. All the applicant is looking for is on-site accommodation at this location for an experienced agricultural worker, which is absolutely essential in this case, and all the information provided should justify a departure from the policies and that prevent this from being achieved. You've got a list of your development plan policies on pages 391 to 407. So the main issues for the local review body to consider: the applicant's agent has submitted new information with the notice of review, which was not in front of the appointed officer when the decision was taken on the 12th of February 2025. This information comprising reference to planning permission granted under reference 220366 PIP, under Section 43 of the Town and Country Planning Scotland Act 1997 as amended, provides that in a review under Section 43A8, a party to the proceedings is not to raise any new matters which were not before the appointed officer at the time the determination of the review was made, unless that party can demonstrate A, that the matter could not have been raised before that time, or B, that it has not been raised before that time was a consequence of exceptional circumstances. On that basis, are members satisfied that this late information should not be taken into account? This is an application for planning permission in principle. As such, there are no detailed matters relating to the proposed dwelling house. Scottish Government Planning Circular 3, 2022, Development Management Procedures, provides that it is for the applicant to decide what level of detail they wish to provide when making an application for planning permission in principle. It also advises that it is open to planning authorities to require further information under Regulation 24 where necessary to determine the application. This can include details of the proposed dwelling house. It is noted that such a request has not been made during the consideration of the application by the case officer. Would members wish to request further details of the proposal via procedure notice, or would members be happy to consider this case without any further such details of the dwelling house, noting that this is an application for planning permission in principle? Members were issued with a supplement pack containing confidential financial information and a labour justification report. If members wish to discuss these documents, we will be required to adopt a resolution to exclude the public from the meeting under Local Government Scotland Act 1973, paragraph 6. Does the proposal comply with the terms of the development plan? In particular, does the proposal meet terms of LTP2, Policy H3 and MPF4, Policy 17 and the associated supplementary guidance on housing in the countryside? In particular, noting that the site is located in the countryside area and is not within or adjacent to an existing settlement, has an overriding, justified and compelling site-specific need been made for this proposed development at this location? Does the proposal represent sporadic development in the countryside? Specifically, has it been satisfactorily demonstrated that there is either an essential need for a second dwelling house on the land holding at Tundergarth Mains, or a genuine robust justification for a dwelling house at the proposed location in operational terms? If it is considered that the proposal does not accord with the terms of the development plan, are there a set of material considerations of sufficient weight to justify a departure from the terms of the development plan? If so, on what grounds would such a decision be made, and what reasons would members give for such a decision if it was considered that the proposal departs from the terms of the development plan? If members are minded to reverse the appointed officer's decision and instead grant planning permission for the proposal, what set of conditions and reasons would members wish to see attached, if any? If members are instead minded to vary the terms of the appointed officer's decision, what changes to the specific reasoning for the decision would be required, and which additional policies, if any, should be referenced? So, having outlined the documents within your papers, it falls to the local review body to determine whether it has sufficient information to consider the review. It's confirmed no representations from any party will be heard today, and like the previous item, members have the options to decide you have sufficient information to enable you to determine the review today, request further information in form of written representations, stating precisely the information it's seeking and who would provide it, resolve to hold a hearing, again specifying who will be invited to speak and on what matters, resolve to hold a site visit, accompanied or unaccompanied, and this can be done in conjunction with any of the above but would not allow a decision to be made today. If you resolve that you have sufficient information and that no further procedure is required, then you have the full powers to uphold, reverse or vary a determination, and the decision notice will include a statement of the terms in which the planning authority has decided the case reviewed. Your planning advisor is still present, and he has not been involved in the case prior to the submission of the notice of review and was not the case officer or the appointed officer for the application. He will provide independent advice as required on matters of planning policy, law or process. And your solicitor is also still present today, and she will act independently if you require specific advice on matters of law. So I'll now pass back to the chair to lead the debate and first decide whether you have enough information to determine the review today. Thanks, Chair.
Thanks very much, Tracy. So we need to do that first. I was going to go through the papers and then decide, but if members are content to decide that first, are members content they have enough information before them to determine this application today? I certainly have. If they're... Councillor Hislop, please.
Chair, it's a sort of preliminary point. Some of the information is exempt, and a lot of that information relates to business sort of issues with regard to the Dodds' farming enterprise. and a lot of it relates to why this is here, it's going to be a case, I would think, that we would use some of that information to actually determine whether we're looking one way or the other at this application. So as it's exempt, should we actually exclude the public at this point, in case something is raised inadvertently?
No, I think we have to rely on folk not to do that, because we only go into session when it's absolutely essential. And it may be that we debate this first and then decide to move to a discussion about the exempt information we have, and then we can move to a private session and then reconvene. But I think it's always good advice. I'll check with our legal expert, but I think it's good practice to do as much in public as we can in the interests of transparency. Laura, do you have any advice on that, please?
I would agree with you on that point, Chair, and just for members to be mindful when they're discussing matters not to stray into any of the business information that the exempt report discloses.
Thank you.
Chair, happy if you want to take members through step by step, as you've done with the previous item, and go through the paper in front of you, and then Robert can show the photographs before you decide whether you've got sufficient information, if that helps you.
That would be helpful, Tracy. Thank you. Aye. Okay, members, so we'll just revert back to the procedure we had on the previous item. Item 1, notice of review dated 7th of March 2025, submitted by John McCall, agent on behalf of the firm of S&L Dodd, applicant, pages 281 to 295. Does anyone have any questions on that particular notice of review? If not, item 2, report on handling determined under delegated powers and rated correspondence, pages 299 to 341. It doesn't appear as if anyone has any questions on that. 3, observation of the appointed officer and the applicant's agent's notice of review, pages 345 to 347. No indication of anyone looking to speak. 4, comments of applicant's agent and observation of the appointed officer, pages 351 to 353. 5, planning application form submitted on 14th of July 2023, associated plans and supporting information, and registered as valid on 26th of July 2023, pages 357 to 381. 6, decision letter from the Freeson Galloway Council dated 12th of February 2025, pages 385 to 388. And then the relevant extracts from Freeson Galloway Local Development Plan 2 and National Planning Framework 4, pages 391 to 419. Next comes the photos of the application site and the locality, and then the grounds for refusal, page 386. So if that member, you're happy with that, I'll ask for Robert to take us through what photographs he has or what he can share with us, and then we need to decide if we have enough information before us. Then we need to decide whether or not to accept the additional information submitted that wasn't made available to the case officer when, I think it was she originally determined the application. So Robert, can you take us through the photographs, please?
Thanks, Chair. Happy to do so. So again, these pictures and captions have been provided to me by the appointed officer. I haven't visited the site myself either. In relation to the submission you have in front of you, there are other pictures from the agent that appear in pages 377 to 379. There's a total of 6 of those. You've got very similar images in pages 293 to 295, the main difference being that they're annotated. And beyond that, you've just got a further picture, I think, on page 325. So the ones you're going to see here are on pages 423 to 424 of your papers. So the first one is a view of the derelict former farmstead to the east of the proposed site for the dwelling house. Second view is of the derelict farmstead to the east of the proposed site for the dwelling house. And the third picture is a view of the derelict farmstead to the east of the proposed site for the dwelling house. And the final picture I've been provided with is an aerial photograph showing the full extent of the application site, including the derelict farmstead within the eastern part. and the site for the proposed dwelling house on the grassed area to the west. Thanks, Chair.
Thanks, Robert. So, members, do we have enough information before us to make a judgment today? I would suggest we do, and unless anyone is otherwise minded, we will proceed on that basis. Councillor Giusti, please.
No, Chair, I'm quite happy to proceed with this today.
Thank you. Anyone otherwise minded? Okay, we have a request to consider information that was not to hand for the case officer when the application was considered. Are we prepared to accept that information today? It's really contained within our papers. Are we happy to determine it without that additional information being considered or taken into account? Councillor Giusti?
I'm comfortable, Chair, for us to take that extra information if other members are minded so.
Anyone otherwise minded? In that case, we'll consider that information as well. So, we are happy to proceed on the information presented to us, and we're happy to accept the additional information for our consideration during the deliberation of this item. And if anyone wants at any stage to discuss the confidential information, please let me know, and we'll move to an off-public venue for that period of time. For me, it's simply a case of what the officer is saying about the application, that the officer accepts that there is a demonstrated need, but not at this location. And I think as well, one of the things we need to bear in mind is we can't tie any house to the land now. That's no longer acceptable. It is a freestanding house that can be utilised for any purpose. Although that's not what the application says, we understand that, but that is what we will finish up allowing if we agree this application. There is nothing that ties the house to the land. But the case officer is quite clear that it hasn't been demonstrated that there is a need for that house at that particular and specific location. And for me, I'd be happy to agree with that. Councillor Giusti?
Thank you, Chair. I think you know already that I'll probably disagree with your conclusion there. I think that there is a demonstrated need, as the case officer has said, and reading the exempt item, I think that proves the need. And when we say that there's not a need in this location, I think they've used this location because it's a site that has pre-existed as a house in the past. I think it does have the merit of, it is technically a brownfield site in the sense of that's not going back to nature without mechanical intervention. So I would suggest that we approve this application based on the merits of the case that we've got in front of us for the business case. I'm trying not to go into too much detail on that, and the fact that we're looking at essentially a brownfield site here with curtilage, that we're not going to have any ribbon development here. I'm satisfied that I think that this should go through.
Okay, well, you have a proposal from me that we go with the case officer's decision, and we support that. And we have a proposal from Councillor Giusti with justification that we depart from that and grant. Is there any support for either proposal? Councillor Hislop?
Chair, there's a comment within the exempt report. It's not a business one. It's a reason which I think was significant to this. If you look at the VETS report on page 375 in the public document, it says it's to help with the identification of animal welfare, and within the exempt document it says the location is where you can see all round the fields that can't be seen from the existing houses. And I think because of animal welfare, that's a reason that we should be considering. We shouldn't be leaving animals lying, suffering for additional time if we can get there quicker. So if Councillor Just is moving that we change the officer's decision, then I would support him on those grounds that the exemption is because of the animal welfare and the ability to see all the areas of the farm from various locations across the holding.
Okay, so you've got a proposal from Councillor Juicy, supported by Councillor Hislop, to change this a decision. You want from me to go with the officer's recommendation. If I don't have a supporter, I take it that I will be able to record my dissent, and that members will have agreed to change the officer's decision and grant this on the grounds set out by Councillor Juicy. Tracy, can you confirm the decision of the committee, please? Laura, I take it there's no impediment to us doing this?
Chair, it was a point of clarity. My understanding of what Councillor Giusti was saying was that he was not going on the basis of need, but on the basis that he thought this was a brownfield site, whereas Councillor Hislop said he thought it was on the basis of need. Perhaps that could be clarified whether there is actually the same motion there, or whether it's, I know that the end result would be the same, but just so that we're clear for the notes, are we doing it on brownfield site, or are we doing it on the basis of need?
I would suggest, Chair, that it's both, that the need is demonstrated, but it's also the site is appropriate and what we would look for when we were asking farmers and agricultural sector to build a house. We would ask them to look for buildings that are currently already on the site or on the farm, or to convert. That is the policy, I believe, at the minute. Use what you've got and build new is the last option.
Okay, does that help, Laura? It's both. It's brownfield site and animal welfare.
It does, Chair, thank you.
Thank you very much. So Tracy, have you encapsulated the member's decision?
Thanks, Chair. I'll just ask our planning advisor to come in on that. And there's also a question of conditions that members would wish to see attached if they're proposing to reverse and approve. Obviously, the original decision didn't mention brownfield sites, so it's whether or not this is a departure from policy or whether members are approving within policy. But I'll pass to the planning advisor. He'll maybe be able to come in on that
That's
point.
great,
Chair.
Tracy. Thank you, Tracy. Robert?
Thanks, Chair. It was just to say if members were wanting, I could advise on possible planning conditions they would want to consider, because I'm aware that this is a planning permission in principle application, so the next application would be approval of matters specified in conditions set out in the planning permission in principle. So but by definition there really do need to be conditions attached to that, and if members want advice on that, I'm happy to provide it.
Okay, I will ask you that, but I see Councillor Juicy wanting to come back in. Councillor Juicy?
Chair, I'm happy within my motion to delegate all planning conditions to the officers.
Are you happy to do that, Robert, or because it's an LRB, do we have to set out what these are?
I could briefly set out what I would do if I was given delegated powers to do that. So basically the first condition would be setting a time limit on the implementation of the planning permission. So in other words, within 3 years of the date of the decision, there would need to be an application made for matters specified in conditions in relation to all of the items. And thereafter, there's a 2-year implementation stage of 2 years from the approval of those, or 5 years from the date of the original permission, whichever is the latest, which is fairly complicated, but that's a standard planning permission in principle condition. You would then have condition 2, which would advise that because it was planning permission in principle, further applications would need to be made in respect of items 3, 4, 5 and 6. And those are what used to be known as reserved matters, but which are now the matters specified in conditions of the planning permission in principle, which would be 3 would be general design, 4 would be site and layout, covering the actual design of the dwelling house. 5 would be covering the finishes of the proposed dwelling house, and condition 6 would be covering landscaping and boundary treatment and hard and soft landscaping within the site as well. Beyond that, I'm just trying to find the Council Roads Planning Team Leader consultation response. I'm not sure if I have that in front of me or if it's in the delegated report. Yeah, it is. It's on page 333. So if I go to that, there might be conditions there that you need to consider whether or not you want to impose or not. Apologies, I'm just navigating the report here. So yeah, the suggestion is that a condition be imposed if you're minded to grant to allow appropriate parking and turning for a house. So basically it would read that the dwelling house hereby granted planning permission in principle shall not be occupied unless and until the following have been provided within the application site. So that's an off-street car parking provision compliant with the National Roads Development Guide, and also a turning area and hard standing sufficient to enable a car to enter and exit the public road and forward gear at all times, and thereafter kept clear from obstruction for the lifetime of the development. Council Archaeologist has also provided comments which appear in pages 315 and 317. And I would suggest, I mean, there is a condition recommended there, but my thought would be that would be better imposed as an advisory directive. So in other words, if that happens, then they contact the council archaeologist and deal with it that way, because I don't think there is any. It does say there's a slight possibility of archaeological finds, so I think the condition's too vague. I think it's a bit unnecessary, to be honest, in this case, and we'd struggle to justify it. So my suggestion would just be on the basis of the 7 conditions that I've set out, Chair, but I would be happy to take forward that under delegated powers if you're so minded.
Happy with that, Councillor Giusti?
Absolutely happy with that.
And just in delegated authority, and Councillor was not in the dissent as well, so that's fine. Thank you very much, everyone, for that. Move on to agenda item number 6. Land at the rear of Ken Lee, Balmaclellan, refusal of planning permission principle for erection of 3 dwelling houses, information of access road 106/PIP. Tracy, do you want to take us through this report again, please?
Thank you, Chair. Yes. Item 6, land at rear of Kinley, Balmaclellan, refusal of planning permission in principle for erection of 3 dwelling houses and formation of access road, reference 24/1064 PIP. So you've got your notice of review dated the 7th of March 2025, submitted by Evans Rural Architecture Agent on behalf of Mr R. Jardine, applicant, received on the 10th of March 2025 on pages 431 to 441. Report on handling determined under delegated powers and related correspondence, pages 445 to 520. Observations of the appointed officer on the applicant's agent's notice of review, pages 523 to 527. Comments of the applicant's agent on observations of the appointed officer, pages 531 to 532. The planning application form submitted on the 22nd of May 2024, associated plans and support and information and amended plans submitted on the 16th of September 2024 on pages 535 to 551. Decision letter from Dumfries and Galloway Council dated the 11th of December 2024 on pages 555 to 558. The relevant extracts from the Dumfries and Galloway Local Development Plan 2 and National Planning Framework 4 on pages 561 to 589. Photos of the application site and the locality on pages 593 to 596. Members should note that the updated response from the Council's Education Service has also been provided as a factual update on page 527. So the grounds for refusal on page 556 are: the proposed development is contrary to Dumfries and Galloway Council Local Development Plan 2, Policy H2, Associated Supplementary Guidance on Housing Development in Villages, and the Scottish Government's National Planning Framework 4, Policy 17, which only permit the erection of new houses in designated villages in identified circumstances, and none of these circumstances apply. In particular, the proposal would lead to a form of ribbon development. This pattern of development is considered to be uncharacteristic of the wider settlement. On page 434, the applicant has asked that the review be dealt with by means of a review of the relevant information that has been provided without any further procedures. So the grounds stated in the notice of review and the notice of review statement on pages 431 to 441, and the comments of the applicant's agent on observations of the appointed officer are on pages 531 to 532, are in summary. The parcel of land forming the subject of this application was the allocated housing site for Balmaclellan in the Stewart Street local plan. This was a material consideration which was not adequately considered or given any weight in the determination of the application. The delegated report makes a very brief comment on this, but fails to give a proper examination as to why the site was not taken across the following LDP and LDP2 documents. Within the replacement LDP, the format was set by the Scottish Government. It was no longer considered necessary to specify or identify each and every particular site across the district out with the main settlements. It was decided in the interest of expediency, operational practicalities and the production of these documents and flexibility that the Council would move to consider what constituted an appropriate site or sites for housing in villages by way of a single generic policy statement and not an area marked on the map. The Council's move away from its previously more prescriptive approach in identifying specific sites in the various villages did not therefore signify any fundamental change in or significantly material revision in the substantive measures used in the assessment of what was or not acceptable additions to a village, but merely to try and make these documents more readable for users. In the settlement hierarchy technical paper prepared for LDP2, the Council confirms the number of locations where no growth opportunities are available will be few and far between, and that some of the factors to be used in the assessment of cases are subjective by nature. However, it is contended that in this instance, given the Council had previously accepted the site forming the subject of this application and the scale of development being shown is on the preferred site in Balmaclellan, this application will enable the village to grow incrementally in the previously acceptable, most viable and appropriate manner, and is of scale in keeping with the size of the existing settlement as required by the terms of the current policy criteria. It is contended that in the context of this particular application, the use and application of the term ribbon development is incorrect and misplaced and is being construed to try and build a case against the application where the pertinent policies and supplementary guidance relating to this proposal are overwhelmingly in support of it. The scale, form, context and the proposed access arrangements of the development proposed do not compare favourably with the descriptions or definition of what may be considered as constituting a ribbon development, and furthermore, it will not result in any of the acknowledged problems that may be expected to result from such a layout of the land. The proposal will not lead to the dereliction of land to the rear of the proposal, high cost in servicing, congestion on adjacent roads, result in an increased danger to those road users, or result in any chance of this settlement coalescing with any adjacent to it, which was the principal concern planners had about such a pattern of growth if it was unregulated. It is also maintained that as a result of the pronounced change in the typography of the land to the north and west of the site, the chances of any further development ribboning away from the proposal are non-existent, and this reason for refusal of the application is being overstated in this instance, particularly as the Council has complete control to prevent any such event happening in the future. Paragraph 4.6 of the delegated report infers that there is a potential conflict between what MPF 4 Policy 17 requires on the matter of further housing in rural areas and what the Council's own policies require. At the time that MPF 4 was adopted as part of the Statutory Development Plan, councils were advised under the provisions of Section 24(3) of the Principal Act that, in the event of any incompatibility between the provision of the National Planning Framework and a provision of a local development plan, whichever of them is the latter in date is to prevail. Despite what the rest of that paragraph may claim about the Council's own policy and supplementary guidance statement, where there is any such conflict, the provisions of MPF 4 are to prevail here, and so the consideration before the LRB when it considers this appeal is whether the development proposed is suitably scaled, sited and designed to be in keeping with the character of the area and the development. It is the appellant's contention that the proposal properly accords with the MPF 4's policy statement in respect of such developments and should therefore be allowed and his appeal upheld in this instance. It is also submitted the comments in the delegated report that this pattern of development is uncharacteristic with wider patterns of development in the village and are somewhat confused and tenuous, particularly where it is in principal application, and design and appearance of any dwellings referred for approval at a later date. The report does not establish or describe how or in what way the use of the land for residential development has become uncharacteristic, when previously the Council had considered such things quite differently when promoting the site for such a development. Indeed, it is stated within the report that the proposed residential use would be compatible with the character and amenity of the area. It is not considered that suitably designed dwellings would give rise to any overshadowing, loss of daylight or privacy concerns to adjoining properties and are likely to comply with the requirements of LDP2 policy OP1A. So in the light of such comments and given the proposal compares favourably against general forms and patterns of housing development immediately opposite the application site and a previous expansion of the village at the western edge north of the church, the appellant does not agree that the proposed development could or should be regarded as being uncharacteristic of the wider area. Contrary to such a suggestion, it is maintained, and as confirmed in the former Stewart 2 local plan, that the site will provide an opportunity for additional housing on the site which will not compromise the setting of Balmaclellan, since the form and pattern of the development being proposed already exists, not only within the settlement but also on the land opposite on the site. A point accepted by the appointed officer, this proposal cannot be regarded as being uncharacteristic. It is submitted that when the form, pattern and scale of development proposed is compared to the context and requirements of the Council's own policy H2 and the examples of the sort of site, the diagrams provided in the associated supplementary guidance, housing in villages, conforms as being acceptable to the Council, it is maintained that this proposed development complies fully and properly with the relevant terms in policy H2. It is contended now, as it was accepted and stated by the Council previously in the recent Stewart local plan, that the site will provide an opportunity for additional housing on a site which will not compromise the setting of Balmaclellan. At a time when the Council has declared there to be a housing crisis in the region and which is widely noted as being particularly chronic in rural areas, it is very disappointing to experience such a contravene resistance to this scheme, when on face value the overwhelming majority of the national and local policies are supportive and encouraging towards this very type of proposal. The members of the local review body are respectfully requested to concur with the appellant's case that the development of this site does accord with the provisions of the relevant statutory development plan policies and in this instance uphold this appeal and grant planning permission for the development. This proposal is confined to the typography of the site and the land beyond the application site boundaries. The pronounced slope that falls down and away from the western and northern boundaries of the appeal site will ensure that there cannot and will not be any ribboning of development away from the site at a later date. The proposed application site was previously found acceptable by the Council for housing development in the village and therefore should not be regarded as constituting inappropriate ribbon development. The proposed development does not extend beyond the limit of the properties opposite, which is a development style and pattern noted in the supplementary guidance statement as being appropriate in such village situations. A significant and material difference between the previous application mentioned in the appointed officer's comments and this case is that the Council recently declared there to be a housing crisis in the region. The Council can do much to help alleviate these problems by adopting a more proactive and supportive approach when determining planning applications in rural areas. It is submitted that the development forming the subject of this appeal can properly be regarded as complying with the relevant provisions of the pertinent policies of the Council's adopted Local Development Plan 2 and its associated supplementary guidance and the policies of MPF 4 it requires to be assessed against. As set out in above and in previous submissions, it is contended that this development 1 proposes an appropriate and acceptable scale, form and layout that is reflective of other established patterns of dwellings within the village and within its immediate context. 2 is the sort of careful considered development that is respective of its location and the form and layout of those situated within its immediate locality, and that it should be seen to comply with the provisions of the design quality of new development supplementary guidance note. 3 will incorporate and encourage measures that are likely to facilitate home working. 4 is the only available development site within Balmaclellan to facilitate any expansion of the village. And 5 complies with all relevant policies applicable to this proposal and the specific provisions and illustrations set out within the supplementary guidance that confirm a development of the form proposed will be acceptable to the Council. You then have your development plan policies listed in pages 561 to 589. So the main issues for the local review body to consider: the applicant's agent has submitted late information which was not in front of the appointed officer when the decision was taken on the 11th of December 2024. This information comprising a written representation from Emma Harper MSP dated the 26th of February 2025 in support of the application was received on the 10th of March 2025. This appears in the published papers at page 441. Section 43 of the Town and Country Plan in Scotland Act 1997 as amended provides that in a review under section 43A8, a party to the proceedings is not to raise any new matters which were not in front of the appointed person at the time the determination of the review was made, unless that party can demonstrate A, that the matter could not have been raised before that time, or B, it's not been raised before that time was a consequence of exceptional circumstances. On that basis, are members satisfied that this late information should not be taken into account? This is an application for planning permission in principle. As such, there are no detailed matters relating to the proposed dwelling house. Scottish Government Planning Circular 3/2022, Development Management Procedures, provides that it is for the applicant to decide what level of detail they wish to provide when making an application for planning permission in principle. It also advises that it is open to planning authorities to require further information under Regulation 24 where necessary to determine the application. This can include details of the proposed dwelling house. It is noted that such a request was not made during the consideration of the application by the case officer. Would members wish to request further details of the proposal via procedure notice, or would members be happy to consider this case without any further such details of the dwelling house, noting this is an application for planning permission in principle? Would the proposal comply with the terms of the development plan? In particular, does the proposal meet the terms of LDB2, Policy H2, and the guidance set out in the adopted LTB2 supplementary guidance in relation to the principle of the proposed development at this application site? Would the proposal fail to comply with MPF 4, Policy 17? Specifically, would the proposal lead to a form of ribbon development? Would the pattern of development proposed be uncharacteristic of the wider settlement? If it is not considered that the proposal does not accord with the terms of the development plan, are there a set of material considerations of sufficient weight to justify a departure from the terms of the development plan? If so, on what grounds would such a decision be made, and what reasons would members give for such a decision if it was considered that the proposal represents a departure from the terms of the development plan? How much weight would members wish to give to the history of planning applications at this site as a material consideration? How much weight would members wish to give the changed development plan status of the site over the years across the Stewartry Local Plan, Dumfries and Galloway Local Development Plan LDP and LDP2? If members are minded to reverse the decision of the appointed officer and instead grant planning permission for this proposal, what set of conditions and reasons would members wish to see attached, if any, and would members request a planning obligation in respect of payment of developer contributions for education? If members are instead minded to vary the terms of the appointed officer's decision, what change to the specific reasoning for the decision would be required, and which additional policies, if any, would be referenced. So having outlined the documents in your papers, it now falls to the local review body to determine whether you have sufficient information to consider the review. It's confirmed that no representations from any party will be heard today. Your options are to determine that you have sufficient information to determine the review today, request further information in the form of written representations, stating precisely the information you're seeking and who will provide it, resolve to hold a hearing, again specifying who will be invited to speak and on what matters, or resolve to hold a site visit, accompanied or unaccompanied. This can be done in conjunction with any of the above, but would not allow a decision to be made today. If you resolve that you have sufficient information and no further procedure is required, then you have full powers to uphold, reverse or vary a determination, and the decision notice will include a statement of the terms in which the planning authority has decided the case reviewed. Your planning officer present has been confirmed that he has not been involved in this case prior to the submission of the notice of review. He was not the case officer or the appointed officer for the application. He is here to provide independent advice as needed on matters of planning policy, law or process. And your solicitor is also present here today, and she will act independently if you require specific advice on matters of law. So I'll now pass back to the Chair and ask him to lead the debate. Thanks, Chair.
Thanks very much, Tracy. And if members are happy, we'll just do the sort of procedure we adopted in the last two agenda items where we'll do the index of context first and then decide whether or not we want to accept additional information, then whether we have sufficient information to make a determination. So, moving on to the index of contents 1. Notice of review dated 7th of March 2025, submitted by Evan Rural Architecture Agent on behalf of Mr. R. Jardine, the applicant, and received on the 10th of March 2025, pages 431 to 441. Any questions on that? 2. Report on handling, determined under delegated powers and related correspondence, pages 445 to 520. Any questions on that? 3. Observation of the appointed officer on the applicant's agent's notice of review, pages 523 to 527. Comments of applicant's agent and observations of the appointed officer, pages 531 to 532. Planning application form submitted on 22nd of May 2024, associated plans and supporting information, and amended plans submitted on 16th of September 2024, pages 535 to 551. 6. Decision letter from the Free Galway Council date 11th December 2024, pages 555 to 558. And 7. The relevant extracts from the Free Galway Local Development Plan 2 and National Plan Framework 4, pages 561 to 589. And the photos of the application site and the locality, pages 593 to 596. And note, members should note that an updated response from Council Education Service has been provided as a factual update on page 527 and grounds of refusal, page 556. So having gone through these papers, I will ask Robert to take us through what photographs of the site he can share with us, and then we'll decide whether we have enough information to allow us to determine today and whether or not we're willing to accept additional information provided and that's set out in our documents. So Robert, do you have any pictures to share with us, please?
Thanks, Chair. The pictures I'm going to show in the PowerPoint presentation match those within your papers on pages 593 to 596. There's a total of 7 pictures. You might have noticed this already, but there are no other pictures within the papers for this particular item. So there's nothing else to mention apart from what I've got in front of me. So the first view is a view of the site looking to the north from the access to Tye Moor, which is the property you can see there. This is a view to the southern site boundary with Kenlee. This is a view to the southern site boundary with Kenlee from a different position. This is a view along the western boundary of the site, and the view northwards from the eastern side of Kenlee, which is on the left. And this is a view of the site from the south, from the west of Kenley, and finally a view of the site on approaches from the east. You can see Kenley there with the bright fence surrounding it.
Thanks very
Thanks.
much, Robert. Sorry, did you want to say more?
No, sorry, I was just saying thanks, Chair.
Fine, thanks, Robert. Okay. Do members have enough information before them to make a determination today? I would suggest we do. If there's any other views, please let me know. And on the additional information, given that we could have had that at any stage, are we prepared to discount that information, or do members want to take that into consideration during the determination? I'm just waiting until Andrew and David finish their discussion.
Sorry, Chair, I was just helping Councillor Slater with his papers. I'm quite comfortable to take additional information if other members are.
Okay. Members, how do you feel? I've suggested we don't. Councillor Juicy suggested we do.
Chair, I'm not precious about it. I'm happy if we don't go with them then.
Okay, in that case, do we have enough information to allow us to determine the application today? It seems Councillor Slater's nodding his head. Councillor Hislop is. So we have enough information. In that case, members, I think we're in session. If there are no views being offered by members of the LRB, I propose we accept the officer's decision, support that, and agree the officer's decision was the correct one in this case. Any alternative views? In that case, Tracy, can you confirm the unanimous decision of the LRB, please?
Thanks, Chair. Members have upheld the decision of the appointed officer and the applications refused. Thank you.
Thank you very much. Thank you very much, Tracy, Laura and Robert being with us today, and thank you members for your input and your forbearance. Thank you very much. And all the business today, that's the meeting concluded. Thank you very much.
Thank you, Chair.
Thank you, Chair.